disability or socially or economically disadvantaged position, unable to approach the court for relief, any member of the public can maintain an application for an appropriate direction, order or writ in the High Court under Article 226, and in cases of breach of any fundamental right of such person or determinate class of person in the court, in this court, that means Supreme Court, under Article 32, seeking judicial redress for the legal wrong or injury caused to such person or determinate class of person. Whether the weaker sections of the community are concerned, such as under trial prisoners languishing in jail without a trial, inmate of the protective home in Agra, or Harijan workers engaged in road construction in the Ajmer district, who are living in poverty and destitution, who are barely seeking out a miserable existence with their sweat and toil, who are helpless victims of an exploitative society and who do not have any access to justice. This court will not insist on a regular petition to be filed by the public-spirited individual espousing their cause and seeking relief for them. This court will readily respond even to a letter addressed by such individuals acting pro bono publico. It is true that there are rules made by this court prescribing the procedure for moving this court for relief under Article 32, and they require various formalities to be gone through by a person seeking to approach this court. But it must not be forgotten that procedure is but a handmaiden of justice, and the cause of justice can never be allowed to be thwarted by any procedural technicalities. The court would therefore unhesitatingly and without the slightest qualms of the conscience cast aside the technical rules of procedure in the exercise of its disposing power and write a letter of the public-minded individual as a writ petition and act upon it. Today, a vast revolution is taking place in the judicial process. The theatre of the law is in fact changing, and theatre of law is fast changing, and the problems of the poor are coming to the forefront. The court has to innovate new methods and devise new strategies for the purpose of providing access to justice to large masses of the people who are denied their basic human rights and to whom freedom and liberty have no meaning. The only way in which this can be done is by entertaining writ petitions and even letters from public-spirited individuals seeking judicial redress for the benefit of persons who have suffered a legal wrong or a legal injury of whose constitutional or legal rights has been violated, but who by reason of their poverty or socially or economically disadvantaged position are unable to approach the court for relief. It is in this spirit that the court has been entertaining letters for judicial redress and treating them as writ petition, and we hope and trust that the high courts of the country will also adopt this proactive bold or indeed approach. Unquote. However, in championing the cause of the human rights of a particular victim or a person or defendant whose rights are violated, the lawyer may find himself supporting an unpopular cause, inviting against himself the force of public disapprobation, the displeasure of the government and security forces, and even his own harassment and persecution by the authorities. For instance, I will have to give you one example. For example, I was once arrested, that was on 31/3/1997 by the state police, and persecuted and prosecuted by the state for my allegedly nexus with the members of the so-called outlaw organization, underground outfits, as I defended their cases involving Dada, etc. in the courts of law. However, after about 2 years, I was discharged from the said case after a prolonged hearing of the charges leveled against me by a sessions court here in Imphal. Another example I would like to cite is that I have also received a number of anonymous treatment letters written in Manipuri and English through post office, and most of them are written in the postcard. I pick up one of the anonymous letters sent to me for your kind perusal, and especially for the perusal of Justice I. Suresh and Mr. Collins. The following is the text of the letter which was sent to me. Haidemani, the extremist advocate, you are indeed a strange creature. Our foolish young men are killing one another every day, but you keep mum. Miscreants planted bombs in bazaars, killing and wounding dozens of innocents every now and then. You always keep mum and look the other way. Our CRPF Jawans are attacked in the most cowardly manner when they were using the toilet, and the miscreants were protected by the crowd. You again keep mum. If our security men took any action to nab the culprits, you are always there to raise a hue and cry in the name of human rights. You mean to break the law and provoke lawkeepers' human rights, and to try to keep the law and protect our hundreds of innocents is against human rights? This is his question. That is not right at all. It is men like you who are violating human rights. Don't forget, honesty is the most policy forever. God is there to punish dishonest wrongdoers one day. Unquote. The above letter, though not a written letter, I think, criticized me in a dastardly and cowardly manner while I was conducting the case on behalf of the victim's family in an inquiry held under the Commissions of Inquiry Act 1952. In that case, 9 poor and innocent civilians who were mercilessly killed and one civilian was severely injured by a team of CRPF at the gate of erstwhile Regional Medical College and Hospital, now called RIMS Hospital, at Lampelphat on the 7th of January 1995. I was appearing on behalf of the victims and their families. This is only one or two examples of the displeasure, harassment and persecution by the government, security forces and others meted out to the lawyers, including myself, who were defending the rights of the victims. A handful of lawyers here and there may have the courage, but most would bow to the force of circumstances. In such a case, the best remedy, in my humble opinion, would be the support of the voluntary organization, NGOs, human rights organizations, lawyers association, like Bar Association, Young Lawyers Forum, and the Myra Paides organization, that means Women Force Bearers of Manipur. One of the main purposes for which the support of voluntary organizations and NGOs for the protection of human rights and lawyers engaged in the protection of human rights, then SAP would be to arouse public concern. Protests by various NGOs in such matter of violation of human rights should be useful. Lastly, I would like to highlight the basic principle on the role of the lawyers adopted by the 8th UN Congress on the prevention of the crime and the treatment of offenders, Havana, Cuba, 27/8/1990, and welcomed by the UN General Assembly in Resolution 45/121 of 14 December 1990. Second page. I would like to read out the basic principles. I shall try. The basic principles on the role of the lawyers. I would like to focus it particularly for the young lawyers. That is why I would like to read. Basic principle on the role of lawyers, adopted by the 8th UN Congress on the Prevention of Crime and Treatment of Offenders, and which was welcomed by the UN General Assembly in resolution number so-and-so. Access to lawyers and the legal service. Principle 1, legal aid. All persons are entitled to call upon the assistance of a lawyer of their choice to protect and establish their rights and to defend them in all stages of criminal proceedings. Principle 2, access to lawyers without discrimination. Government shall ensure that efficient procedures and a responsive mechanism for effective and equal access to lawyers are provided for all persons within their territory and subject to their jurisdiction, without distinction of any kind, such as discrimination based on race, color, ethics, ethnic origin, sex, language, religion, politics, or other opinion, national or social origin, property, part, economic, or other status. Principle number 3, binding of legal aid. Government shall ensure the provision of sufficient funding and other resources for legal services to the poor and as necessary to other disadvantaged persons. Professional association of lawyers shall cooperate in the organization and the provision of previous of services, elicited and other resources. Principle number 4, information on the role of lawyers. Government and the Professional Association of Lawyers shall promote programs to inform the public about their rights and duties under the law and the important role of lawyers in protecting their fundamental freedoms. Special attention should be given to assisting the poor and other persons so as to enable them to assert their rights and where necessary call upon the assistance of lawyers. Special safeguards in criminal justice. Principle 5. Right to be assisted by a lawyer. Government shall ensure that all persons are immediately informed by the competent authority of their right to be assisted by a lawyer of their own choices upon arrest and detention of when charged with a criminal offense. Principle 6, legal aid. I would like to sum up these things. This is the legal aid. Then principle 7 is the proper prompt access. Principle 8, adequate, appropriate to consult lawyers. And qualification and training. Principle 7. Principle 9 and 10 is about the qualification and its training. Then principle 11, disadvantaged group. Then duties and responsibilities are found in the principle 12, principle 13 and principle 14. As a principle 14 I would like to read out. Principle 14, human rights. Lawyer in protecting the rights of their client and in promoting the cause of justice shall seek to uphold human rights and fundamental freedom recognized by regional and international law, and shall at all times set freely and diligently in assistance in proceedings with the law and the recognized standard and ethics of the legal profession. Then principle 15 is respect interests of client. Then principle 16 is about the general guarantees. Then principle 17 safeguards. Principle 18 non-identification. Principle 19 right to appear in court. Principle 20 civil and penal immunity. I made it out. Lawyers shall enjoy civil and penal immunity for relevant statements made in good faith in written or oral pleading or in their professional appearance before a court, tribunal or other legal or administrative authority. Then principle 21, principle 22, confidentiality, and principle 23, freedom of expression. Then principle 24, professional association. Principle 25, cooperation, and disciplinary proceeding is in the principle 26, code of professional conduct. I may read out this thing. Code of professional conduct for lawyers shall be established by the legal profession, though its appropriate organ by legislation in accordance with the national law and custom and recognized international standard and norms. Principle 27, complaint. Principle 28, fair trial. Principle 29, proceedings in accordance with the code of conduct. These are the basic principles on the role of the lawyers in order to protect the human rights and other rights of their client. This is my simple paper, and we may discuss it with the Honorable Justice I. Suresh along with my brother, Mr. Nalukman Purnaway, and you may like to comment, you may observe in this question. Thank you.
Thank you, Sri Haider Mani Singh. This paper is open for discussion. Thank you.
I have one clarification. Not clarification exactly. It's been said in your paper that you were arrested on 31/3/1997 and subsequently released after prolonged. Now the question here is, the whole contention of you putting it here is that you have been harassed and your rights have been violated, and later on you have been released by the court.
You identify yourself when you speak, that you be better with us.
I'm sorry, I'm Jindal Mukhachandra, I'm from the Statesman. I represent Manipur from here. So, coming back to the question, you have been released after prolonged hearing. Now the question here is, since your rights have been violated, what are the remedial procedures that you took up, or what are the, since you have suffered, there should be some remedies coming towards you. So as a lawyer, what was your demand after the case was closed? Did you put up an extra case, or was it just closed like that?
I've got a chance to file the damage against the wrongdoers, against the police investigators and others. But still, I am not filing the case. The best remedy is to file a malicious prosecution, as always, civil suit for compensation. These are the means. But I am not taking these things.
The question is why? Because in most cases in Manipur, what we find is that people don't really go back to court and file.
Because you see, Mr. Lukasana, it will take a long time. And that is why I do not like to do so. Because I'm involved in social works and in human rights organizations That is why I do not like to file the malicious prosecution, because the charge has already been discharged by the Sessions Court, and because it was a revisional court, it was tried by the Additional Chief Judicial Magistrate in Impal, and I filed a revision against framing of my charge, and thereafter the Session Judge discharged me from the charges leveled against me.
But the underlying question is not the time frame. Why should we not ask for damages from the authority which is supposed to have trampled upon my rights?
Yes, we may ask and we may file for the damage.
Finish my observation, please.
Yes, we may file the damage.
What we have observed from long time reporting in this area is that people don't really go back to court for damages. And there has been no instances of single damage payment by the authorities after these incidents. The lawyer being a profession which should be most informed about these rights, we expect you to be one of those forerunners to be applying for the damages and taking the authorities to the court and then finally getting a settlement which will prove that they cannot just go about filing cases against anyone without having any cases against them.
It can be done, but I was not in a position.
I'll just explain. See, under TADA, yesterday I said, 73,000 odd persons were detained under TADA. It is essentially a detention law. Ultimately what happened was, prosecution was only in respect of about 3,000 odd accused. The rest were all arrested, their life got ruined, they were not given bail, finally the cases were all dropped. Conviction under TADA is again only 1.8%. So even Rajiv Gandhi's murder case, other day Supreme Court said they cannot be convicted under TADA. General Vaidya, who was the leader, who was the one who killed the Punjabis in Khalistan, he was shot dead by Chinda and somebody in Pune. Charged under TADA was not convicted under TADA. The conviction under TADA is just 1.8 and hardly any conviction. The main question, as you rightly said, is what happens to the lives of all these persons who have been arrested under TADA? What's the remedy? Now, Ademani, of course, he's a lawyer. He has a right to file a case for malicious prosecution. He has a right to file a claim for damages. But of course he knows this case itself. Our system of law is such today, individually, if you have to file cases, it takes his own time. It takes money. Of course, for a lawyer he need not spend. But for other litigants, lawyers will charge their fees. The court fees is there in our system. They have to pay court fees and wait for indefinitely for 5 years, 10 years, and then appeal and so on. You see, Justice Krishna has said in India, what happens is, life of Indian is short, but the life of litigation is long. See, this is how it happens. And therefore many people hesitate to go to a court of law and file a suit. But under the international covenant, you see now, there is an express provision that if a person has been wrongly arrested, wrongly detained, and wrongly tried for any criminal case, he must be given compensation. So I have been arguing now, see, on the criminal procedure code, there is no proper provision there for payment of compensation. So I am suggesting that in a conference in Bombay, amend criminal procedure code. The judge concerned, at the time the case is tried, he comes to the conclusion, this is a false case. Fix the government compensation there itself and direct compensation will be paid. Now this kind of, so our law requires to amendment. Otherwise, individual, of course, there are people who have filed. As he has rightly said, of course, he has taken a decision not to file, okay, he doesn't bother. But there are others, not that he is not aware of his right, he is aware of his right. There are so many others who can be advised to file. But at the same time, so for example, that one case which came back from the Supreme Court, what is that case of 1989? Finally, now, yesterday somebody said, he's filed a suit for damages. Just imagine, detention was killed in 80 or 81. The Supreme Court decides the case after 17 years the Supreme Court decides, and then investigation now by the police, and then filing a suit for damages, and then meanwhile observed one of the mother's side. But this is kind of, the whole system is wrong. So therefore what we require is an amendment of the law. Criminal Procedure Code has to be amended, and the judge and the magistrate will be given powers to grant compensation in all false cases on the spot. And so that this kind of another litigation, ground litigation is not required. Of course, judges Supreme Court is doing it now on its own. See, initially, wherever a person wrongfully arrested, what the Supreme Court did was, okay, release him. Habeas corpus, people release him. Then the next step came after some years, okay, not only release, but prosecute the person who had wrongfully arrested a person. So then the next set of decision came from the Supreme Court. They prosecute the man who was wrongfully arrested, a person like Kalebani. Okay, prosecute an officer. Then again the third step came, no, pay compensation. So today Supreme Court does grant compensation. But it's only the Supreme Court, the High Court are doing, not the magistrate, because they are got inner writ jurisdiction. Under Article 226 or in the Supreme Court they have inherent powers, and even under Article 32. Where step went further, and that is where the Supreme Court said that why make the state pay the compensation? The officer has done it. The officer must be made to pay the company himself. There's a case called Lucknow Development Authority case, because of the consumer law, but the Supreme Court said the person officer concerned must be made liable to pay the compensation. And that was what was applied in the case of, you must have read the case Satish Sharma, who was a minister in the central government, who allotted all the petrol pumps, so many persons. And Justice Kuldeep Singh said, you have misused. You have diverted money belongs to the government, the property belongs to the government. So he said, pay 50 lakhs back to the minister personally pay that money and by using this judgment. Unfortunately, of course, the later judgment reverted that. Then, of course, a different issue altogether. So what we require is a change in the law.
Thank you, sir, for the clarification. But still, I would, to get that Supreme Court rulings placed, someone has to start filing the case first. So, in case of a learned advocate, I would still say that he should have gone ahead and filed a case, because it does send out a wrong signal to other people who would start considering even a lawyer. Like you rightly said, it takes a lot of money for common people to file. So if a lawyer who does not have to spend that kind of money, who still has within his ambit to use his power to file a case, if he doesn't file, then how would I be able to file? So in a situation like in Manipur, I think Hadimani, of course, is known to have both.
Still file. It is really limited. If you want to do it.
So I will still.
But I don't know, that is left to him. I think what you have to do is tell the people you have a remedy, but also tell the people you have waited for a long time. That is what is passing. I would see even that magistrate's case was tortured. The report is made by the High Court. Now this clear evidence is there as to what has happened. The magistrate himself came and complained to the High Court. High Court did defense very strongly. They got up from the seat and they said we protest. Then ordered inquiry. But afterwards, what has this High Court done? 94 the report has come. They don't even keep the matter on board. They should have kept the matter on board. Call their police and army officers and say, look here, this is what we get from the report. Why not we prosecute against you? So, recommend the central government to prosecute his officer forthwith. They should have done that. But even High Court doesn't feel that strongly. That's the problem. Our judges will feel strongly. Justice lawyers will feel strongly. But that is not taking place. See, this is one of the things that we are witnessing. Yeah. Okay.
Can I request you as a journalist? Maybe he has not filed the case, but there are cases pending now for the last 5 years where the victims have asked for compensation. And inquiries have been ordered and inquiries have been concluded in favor of the victims. Namely that they have been picked up by the army, tortured by the army and so on. So those inquiry reports are also pending before the High Court. Now all those cases are pending. Your High Court actually is not so bad as compared to some other High Courts. They've been taking some action. But on delay, the High Court is making some little bit of a fault there. I don't want to say too much. So if as a journalist you can point out the number of cases pending before the High Court and ask the High Court to please expedite these matters, I have a feeling you may achieve what Hyderabad will not achieve. Try and do that. And secondly, this case of this judge who was tortured in 89, report is 95. And the finding of that report is in favor of the judge that he was tortured by the army. When you write an article, just request the High Court to please take up this matter. Citizens want these matters to be taken up urgently. So maybe you can set a new trend in Manipur for having these cases. I think the ball is in your court also.
I think we have 2 courts. One in your court and one in my court.
I refer to last page, middle portion. Here, a handful of lawyers here and there may have courage, but most would bow to the force of circumstances. What is the reason behind this?
No, this is very simple. There are a handful of lawyers in this, myself, you yourself, and Mr. Abe, and some of us. Maybe a handful of lawyers. That is why a handful of lawyers here and there may have the courage, but most would go to the force of circumstances. That means others may force the circumstances created by the security forces, by the commandos. That is what I am saying.
You mean all those are afraid of security forces?
That means, yes, that may be. Some may be both the security forces.
But can we suggest some sort of ways and means to
For that matter, I have already mentioned in my last, that means in the same para, that the base remedy in the next para, in the next sentence. Force of circumstances. In such a case, the base remedy, in my humble opinion, would be the support of voluntary organizations, NGOs, human rights organizations, and the lawyers forum. And your young lawyers forum is also necessary, and bar association, as well as the here in Manipur, Myra Paidis, which is known as the Women Post Gatherer, will do certain things by protesting all these things. This is my suggestion. My suggestion is also there.
In addition to question of Mr. Rakesh, then my question is not question
Suggestion.
yes. Support of voluntary organization and NGOs for the protection of human rights and lawyers engaged in the protection of human rights can serve would be to arouse public concerns. But here my suggestion is that my sir, then as this organization, Marabaivis or NGOs and people in general, when they look up to us as a lawyer for their help and for the protection of the human rights, then here my suggestion is that what support we need from them. Then because they need support from us, they need some advice. That is the legal advice from us. Then here my suggestion is what is the meaning underlying the support? What support? I would like to know.
That means, you see, that means protests, meetings, demonstrations, as well as representation to be given to the state authority, as well as to the national authorities. These are the supports. We may be given legal advice to the masses, and they, in their turn, will move before the authority, including the governments and the security forces. They may raise questions. They may raise in the form of meetings by the meeting.
Sir, I would also like to supplement the question by Mr. Rakesh. Regarding this point, sir has pointed out that we need to have some sort of contact with the voluntary organization, NGOs and human rights organizations.
That is why I mentioned.
Right. I totally agree with that. But the question is, as a lawyer, when we should be the one who should be being in the forefront, we are going back to this organization who are mostly swayed by emotions. For example, Myra Paidis, for instance. Of course, it's a very pressure group now in Manipur. But if we realistically see, There are times when it is swayed by emotions. My point is that we, as a lawyer, who should be having legal knowledge, legal experts, and rather than going for our legal, demanding our legal, through our legal rights, why should we be? Of course, we should take note of it. But I think my suggestion is we should rather be going to the legal forum. That's what I feel.
That's right. That's a suggestion, that's your comment, and appreciable. But sometimes court cannot protect our lives. Legal law cannot protect our own lives because ours is not a, what can I say? It is not a well-to-do society.
I agree with you.
Ours is not a, it is not a well-to-do civilization. It is in the name of democracy. We have no rule of law in our districts. That is why only court cannot protect our lives.
So there is where and my particular question is, there is no rule of law. So don't we have a big role in bringing rule of law? Because going back to this organization, not that I don't suggest that we should not go back. Of course we should go back. But going back to this organization to bring rule of law, sir. My question is that.
Then for that matter, we may move through legislative assembly, through parliament. That is the People's Forum.
Can I say something? See, how many lawyers do human rights defenders work? We have in Bombay, Kulin Duksan is there. There's got lawyers. Then we have got one or two other groups. Maybe in a city like Bombay, where we have about 10,000 lawyers practicing, you'll find at the highest 50, 60 or 100 lawyers doing the human rights defenders work. The rest of them are not interested in doing human rights work. So each one must have some kind of commitment. Then of course you do it. Other day, lawyers were appeared and almost visited the court in Bombay and told the judges to pass an order whereby large slums have been demolished, are being ordered by the court. And I talked to the lawyers. I met those lawyers, some of them, who got that order. I told them, look here, have you gone and seen the place where these hospitals are situated? They said, no, they have not gone. Then how could you argue that go to the court and say, these are a nuisance, and they have done this, and so on. So you should have gone and seen. As a result of the order, nearly 5 lakh persons are in this house. Have any kind of feeling? The lawyers don't know what to tell me. Sir, we have to do it in the interest of the city. They have their own notion. They don't feel strongly about right to life. They don't feel strongly about a poor man's right. They don't feel strongly about human dignity. They only think in terms of money. See,